So not seeing anything lighting up anywhere or not hearing any noise, I would like to turn now to, 2 minutes ahead of schedule, to future agenda items and also action item review. Dory and I have already been working on thinking about the next meeting, and so I'll ask Dory to talk about what we're thinking about. But I really see this as a work group effort, not driven. We had to come up with the first agenda to move forward, but I want to be sure we're doing things that are helpful to you in making your recommendations and decisions as we go forward. Some things are obvious. A number of things were brought up today that we will provide material or have further discussion. I keep saying, and I of course hear people saying it because I'm saying it, I represent this group. I think you bring the perspective of that group to this discussion. I don't really see anyone representing anyone. I see you as your individual members here as part of this group to have part of a collective discussion and understanding. And so it's not like, well, my people told me to vote this way, so this is the way I'm voting. Well, you learn right away, of course, section and board people, at least it's finite, but section people, that's like, really? How do you ever assess that? Board of Governor people, you represent the whole state. But you're bringing a perspective and you're being sure their voices are heard as you understand them, and the public as well, and the tribes. And so I just want us to be thinking about us bringing perspectives and making sure we're all hearing it, but somehow not thinking we're representative. We are the representatives. Our group, we are the group that is going to decide the recommendations that will be made to the Supreme Court, and then the Supreme Court will take it from there. And I will just be the carrier of the message to them. Of course, I'll have a vote when I get there, but I'm not going to influence their thinking of what we as a collective group present to them. So I want you to, well, I think we should do this, so therefore ignore that. No, here are all the things. We'll have the discussion at the court, and when we'll vote, and when it's time to vote, I'll vote for what I believe in. But this is not for, I want you to understand my role is sort of as the facilitator, the neutral, the leader, the collaborator. But that's how I view us going forward. So I'll let Dory talk about what we're thinking about quickly so that you'll know. And then if there are more things you want or are thinking of, I'd like you to identify them, and we'll fit them into the agenda the best we can. And then I'd like to talk about how we felt this meeting went. Dory.
So contemplated, at least for the very next meeting, is a further exploration of some of the things that we've touched on here with respect to, and so in a post-Janus era, what does that mean for bar associations specifically, if anything? How are other state bars being sued, or what sort of litigation is pending currently in this new era? And or how have other states made decisions? How have they restructured, bifurcated, changed not at all, explored? Hunter, your questions about, are there any work groups that have gone before us? We want to try to take stock of what other states are experiencing. So there's an associate dean at Seattle University who's understood to be a Janus expert and in this area, and she's agreed to come and address us. Her name is Charlotte Garden, and so we'll contemplate having her on the agenda to start some of those discussions, and then possibly additional presenters again with the further exploration of how other state bars are reacting and or being sued in this era.
So Paula Littlewood, current executive director of the State Bar. And also I expect Paula Littlewood, who is an expert in this area and is unavailable for this meeting and also unavailable for the next meeting because of family commitments, will come to our third meeting, and we will have the benefit of her thinking. We had the benefit of her presentation that she made to the National Association of Bar Executives, but I think it's important that we hear from her as well as an expert in this area and a person who has spent a lot of time thinking about this and anticipating it, talking to the court about it, talking to the Board of Governors about it, talking with her executive team about it. And so Paula will be a resource to us as the continuing WSBA executive team is. I know Professor Spitzer is very interested in this area and has been thinking about it. There are other people that will become known to us, or that are known to us, that we will see if they're available and willing to come talk to us, to give us their insights and their thoughts. Because I'm a firm believer that wisdom does not reside in only one mind, and that information from many places will help us have a better understanding of the lay of the land, and so we can make the best decisions we can with the information that's available to us at this time. One of my colleagues said, well, until the Supreme Court decides, we won't know. Well, in one sense, that's true. But there is thoughts, probably on both sides, of where it would go. Their thoughts. It was so interesting to hear Professor Spitzer today talk about the three choices in 1933. We have that's like deja vu almost all over again. So I think it's good to have an opportunity to talk about this and to think about the future and what makes sense, whether it's driven or whether it's a choice that is made. So other thoughts, agenda items, speakers, Paul.
Yeah, I guess I'd like to have on the agenda discussion of the legislation ES-HB 1788, which sort of evolves on a day-to-day basis. I see that there are 3 more amendments, potentially being proposed today. I testified on the legislation, as did Professor Spitzer last week, and also as did Governor Schicchetti. That legislation, as it's currently modified and existing in front of the Senate Law and Justice Committee, seems to continue the entity, which is a good thing. I think that change was probably made in response to our testimony. Dory probably knows whether or not that's true. But it does do away with the Board of Governors and a huge chunk of the policy-making function of the entity. So I'm curious, at some point, we'll probably want to discuss how that, what the implications are for this work group and our alternatives, and how those implicate, how the alternatives may be affected by that. One concern I could see, for example, is, without the Board of Governors and without that policy-making function, do the sections do better off in a completely separate entity at that point?
Okay, thank you. Did you want to say anything, Dory?
Well, with respect to the striking amendment that Senator Jamie Peterson, the chair of the Senate Law and Justice Committee, signaled he was of a mind to consider for executive session, it does appear in a slightly different format than the version of the striking amendment that the committee first heard public hearing on. And so just as a product of the timing that it was produced after the public hearing, I think there's an inference that can be drawn about the motivation to alter it. Beyond that, I don't have actual knowledge of what motivated Senator Peterson to make the small adjustments that you see there.
I guess a question I would have is, what makes you think the Board of Governors is going away based on that bill?
Because it says it does, I think. What it currently says now, and it's hard to keep up because it changes every few hours, is that it used to say that the entire Bar Act was repealed and then certain sections were reenacted. Now it says nothing about repealing the entire Bar Act. It talks about repealing certain sections, and the sections that are to be repealed include the Board of Governors, the election of governors, the role of governors, I'm pretty sure. Is that, Dory, would you agree with that?
The section preserved in Title II 48 is the one that references the association as an entity. That is the one that's preserved and maintained in that particular chapter of RCW in the executive session striker. There are 2 sections of existing Chapter 248 that would be amended and recodified in a title that is 244 RCW, specifically about attorneys at law. So 2 provisions kind of moved in code, and then 1 that remains to preserve the entity that is in 248.
And so one of the key changes is the elimination of the Board of Governors, correct?
Statutorily, yes.
Right, but my point is, until the Supreme Court acts, it would be in effect through that effective date, and I don't have any reason to think that we wouldn't, at this point, depending on what comes out of this group, continue as we currently exist. It would just be under Supreme Court authority. So I think assumptions might have been made that may or may not be correct, and we just have to wait and see what happens. So I understand it takes away the State Bar Act, but I expect that until this group comes up with a recommendation that is something else, we will continue as we are. That's my expectation. Okay? Other thoughts or comments for future agenda items, speakers, people you would like to hear from? Yes, Hunter.
For future agenda items, do we know if there will be a dedicated block of time specifically to hear from any members of the public on this issue? I know with time being at a premium at these meetings, sometimes it can get stuck until the very end. So I'm wondering if we want to consider dedicating a certain block of time.
I think it would be I think it's a very good point. I think it'll be very important to hear from members. I imagine after we have the informational sections, which hopefully members who are interested in are either tuning in or will go back and watch our meeting online, would be in a position to come sort of after we have our discussions to give their input, and then once we come up with the various recommendations, to then have an opportunity to comment on that. So it was my hope that we will, or it's not my hope, it's my intent that will be part of it. And I think that's part of our structuring. When's the right time? So there's one thing having questions and clarifications right now while we have information, but I think it's very important. And I think there's no intent not to hear from them, but it's important that we stay focused, our group, and moving forward, because you could spend years talking about it. So we're going to find that hopefully appropriate balance of input. And it may be that we'll have written input that we would then review and could discuss. It may be we have questions that would come in. So I think as we move forward as a group, we can discuss what we think would be most beneficial or allow us to have the greater input. Please, Esperanza.
Thank you. Can you hear me?
If you speak up a tiny bit more.
Okay. I can speak up pretty loud.
Thank you.
Yeah. It was very helpful to hear kind of all the pieces that make up WSBA and to consider a lot of things sitting here. And one of the questions that comes to mind to me is, are we going to cover other structure issues at WSBA in these meetings, such as procedures on how to deal with harassment allegations? Will we be talking about those? Can we bring those here?
Well, I think we as a group can discuss that, but right now the bar is working on their policies, and with the Board of Governors, I don't think it's actually within our scope, but I think if there are concerns or questions that members have, that we can direct that to the bar and to the Board of Governors to do that. I think that could be its own complete separate work group, which at this point we are not, the Supreme Court is not establishing.
I understand that. And I also just want to say a word about, for the work I've done over the last 4 decades, the whole issue of race equity and justice is paramount in what we're doing. And so thinking about how the decisions that are going to be made here, the recommendations that are going to be made here, how they're actually going to play out on the ground to the people who need the services from an attorney, and as somebody who involved in addressing the issues of people, low-income folks, I'm very much keeping in mind how what we do in these next few meetings that we have, how that's going to have an impact, and that all is on our minds as we're moving forward.
Thank you. Eileen's going to be our last comment because we are at noon, and then we will take more input from everyone and then work together in the next agenda and materials. Eileen?
I'll be brief. Just as we go through the issues that you've identified here and look at possible structures, to have just a paragraph or section on the impact on employees of this. Here I'm mainly thinking of the fact that now bar employees are members of PERS, and if you go to a completely voluntary association, then that will be a significant impact both on recruitment and retention and the current folks currently doing the work.
Thank you, Eileen. With that, I'm going to thank you all for coming. If you have feedback on how I can run the meeting better, feedback or additional agenda items or speakers, please let Dory and me know, or my assistant, Cindy Phillips. Margaret, thank you all for your help. Thank you to the bar for hosting us. And we will see everyone at our next meeting, which is on April 8th, and it's a 1 to 4? Correct. We sort of split them, so hopefully we wouldn't screw up all your schedules. So thank you all for attending.